On 23rd May 2022, the Ethics and Medical Registration Board of the National Medical Commission has published the draft National Medical Commission Registered Medical Practitioner Professional Conduct Regulations 2022, inviting comments and suggestions from public, experts, stakeholders, and healthcare providers. Strangely, medical societies who should have been at the forefront, proactive, seem to be disinterested in this exercise. Doctors in India have never realized the importance of these statutory codes of professional conduct. But then, let us not forget that we are in 2022, an era where healthcare is getting more and more laws, more and more regulated, and laws are getting more and more stricter for everyone. This proposed regulation is therefore very important for all the stakeholders in healthcare, especially for doctors. This will become a very important part of the statutory law, the written law, and will control and regulate the conduct of doctors in India for a long time to come. It will impact and regulate important aspects of a doctor's conduct, right from writing a prescription to taking an informed consent to preserving medical records of a patient who is discharged and so on. This regulation will declare what conduct is correct and what is incorrect as far as doctors are concerned. It will prescribe what acts of omission or commission would constitute indiscipline and what would constitute professional misconduct and the punishment for the same. This regulation will be sacrosanct to such an extent that no court in India, not even the Supreme Court, can pass a judgment that is contrary to or inconsistent with what is laid down in this regulation. The most important aspect, this regulation will remain in force for a long time to come. The earlier statutory code of conduct for doctors, the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002 has been in force for the last 20 years. It is therefore important that doctors and medical societies should discuss and deliberate this draft seriously, extensively. Every provision must be discussed threadbare. The problems that they face in delivering healthcare services, the legal protection, the legal validation, the legal support that they need to deliver their services in a more efficient, cost-effective and patient-centric manner must be suggested to the regulator. Even minor changes in this regulation could in some instances provide great protection to doctors. To illustrate, today there is a lot of confusion on what medical records must be preserved, whether only the copy of prescription will do or whether the investigation reports should also be kept, or in case of an IPD patient, whether copy of the bedhead ticket is enough, whether scanned copies of the original medical records are good or not. If this regulation could specify which medical records should be preserved and in what way, it will clear the confusion for all times to come on this aspect. It will also make things easier, even for the courts, in cases of medical negligence. Medical societies should therefore send their suggestions and or make their representations before the regulator, the National Medical Commission. This exercise must be taken seriously. It is also a big opportunity to make the difference, and the time to act is now. Thank you.